organizations, what it will turn out is to be seen. Okay, we are hoping that it will turn out really well. Okay, so we as from our Cybersecurity Center of Excellence point of view, this is of great interest to us. We are in touch with a lot of organizations, including IDR, BT, and with Telangana government and various different organizations in order to shape the ecosystem and help uplift the cybersecurity and privacy ecosystem. So our motto always has been security by design and privacy by design, security by default and privacy by default. We are, in case many of you don't know, we are incubating about 55 cybersecurity startups here in cybersecurity and privacy. Privacy is a growing domain, and we are hoping that we build expertise in privacy engineering, because once privacy laws are there, then organizations will naturally ask that in the widespread and sprawling organizations and with a lot of interlocking functions, how do we, and extensions or interfaces with many other sub-organizations, how do we implement privacy? Yes, we want privacy, we want to implement it, we want to stay out of trouble, and also we are keen on protecting the data privacy and protect our data, personal data, but how do we implement it? So there, we'll have to turn to privacy engineering and PETs, privacy enhancing technologies. We'll be holding in the coming weeks several sessions on that. But now, of course, I'll give it back to Sai Prakash.
Thank you, sir. Thank you so much for addressing our audience. Without further ado, now I would like to invite our today's speaker, Advocate Puneet Bhasin garu, who is a cyber law and data protection expert and the founder of CyberJure Legal Consulting. Apart from that, she is the advisor to Rajya Sabha Committee on Legislative Reforms for Technology Laws in India and recipient of 15 national level awards for her contribution in cyber and data protection laws and practice in India. Ma'am, the floor is yours.
Hi, at the outset, happy Privacy Day to all of you, and glad to meet all of you. Many of you may not have met me prior. Some of them may have met me prior. So at the outset, a very warm welcome to the new year to all of you. So we are still in January, ending of January. So wishing you all an amazing year ahead. And yes, privacy has been the theme for 2025. Honestly, privacy has been a concern for the last 10 years, since when smartphones have made their advent into everybody's hands. But yes, with the Data Protection Act, legislations, now the rules, it's something which is gaining importance in perspective of individuals and organizations realizing it. Again, I would say individuals, organizations realizing it more from the penalty perspective. So that's exactly where the whole thing is stemming from. Can you just go ahead in the slides, please, Sai? The next slide, please. We'll have to run through a few slides, please. You can follow on YouTube for more lectures. Let's move further. Yes, so the initial part is about the Data Protection Act. Please come on the next slide of that. So we are just going to see an overview of the Act before we delve into the rules. So yes, my presentation has a detailed understanding even of the Act, but we won't be doing that today. So why exactly, first of all, did the rules and the Act come in such a hurry? It was not meant to be a legislative throw in the face of every organization. The entire thing has been brewing for quite a few years. The reason it gained paramount importance is, as I'm quite sure most of you are aware, that warfare today has become cyber warfare to a great extent, which means misuse of data is something which is the biggest concern for any government, including our government. So wherein there may be nations in any different situation, nation state actors who can misuse your data, misuse data of individuals, geolocation tracking, which can be utilized for multiple other purposes also. So there are so many other complications that come up with individuals' breach of privacy. Now, honestly speaking, whether or not you may have realized, each one of us has been breached. Each one of us has faced a breach of our privacy, whether it may be from different applications of shopping, whether it may be music applications, whether it may be tracking applications, gaming applications. Every other application is technically breaching our privacy. They're getting away with it at this point of time, but that doesn't mean that that's exactly how things have to remain. So the risks associated with this form of breach of our privacy is also very serious. I'm quite certain in many of you who are, of a particular generation over here, not the very young people, you would have heard that, from the elders in the family, कि आप जो काम करें एक हाथ करें तो दूसरे हाथ को सुनाई भी ना दे. अभी जमाना ऐसा है, एक हाथ में मोबाइल फोन है, दूसरे हाथ से आप काम कर रहे हैं, ये मोबाइल फोन आपको पूरी तरह से प्रोफाइल कर रहा है, आप जो बोल रहे हैं, आप जो कर रहे हैं. तो तीसरे इंसान को पता चले ना चले, आपके मोबाइल फोन में हर चीज पता चल रही है. आपने ये कहावत सुनी होगी आपके दादी दादा नानी नाना से, दीवारों के भी कान होते हैं. आज दीवारों से ज्यादा तो आपके स्मार्ट टीवी के कान हैं, आपके स्मार्टफोन के कान हैं, आपके पास हर डिवाइस जो आसपास है उसके कान हैं, एंड इट्स लिसनिंग टू एवरीथिंग एंड एनीथिंग पॉसिबल. So there have been multiple cases. So whether it may be with respect to WhatsApp coming out that, oh, there was a blip is why there was recording going on. I'm quite certain aware about Alexa also. You're aware of almost every application that has existed, that is operating, training on AI, going ahead and probably providing some social media services. Most of them are collecting your data. That's an absolutely quite direct breach of your privacy. Right now it's a breach because there is no form of concrete regulation. There is a law that is there in the regulation enacted. Organizations are still not complying. Once the body is formed, the Data Protection Board is formed, is when the penalties will start for these non-compliances. So yes, from the year 2023 October is when the law is enacted, is applicable. And once the board is formed is when litigation pertaining to the period from enactment to the date of formation of the board and post that, all of that would come up. Now, with respect to the applicability of the Act, now when we are talking about the Digital Personal Data Protection Act, as the Act itself says, it pertains to digital personal data. But my question comes in, what data is only physical today? Almost every organization is digitizing data. So even if you're collecting data in a physical form, somewhere or the other, you're doing a data entry of it in a digital medium. There may be a photograph taken of it. Sometimes even an image taken and transferred, let's say, to another service provider for data entry constitutes digitization of personal data. So by default, any and every organization is coming within the ambit of the Digital Personal Data Protection Act, whether or not they like it. The meaning of a data principal. Now, who is a data principal? The organization or the body which is determining the collection of the data. So they are determining the purpose of collection, the utilization, the timelines, how it's being stored, secured. So the organization which is determining all these things is called the data principal. Sorry, is called the data fiduciary. That's my mistake. That's called the data fiduciary. So a slip of the tongue. A data principal is you, me, us as individuals who are going ahead and sharing our data on multiple platforms with the data fiduciary. So the data fiduciary is the body or the organization which is going ahead and determining the reason, the contractual obligations pertaining to third parties with whom they are sharing the data, the processing of our data being given to other third parties, or maybe they themselves are doing the same. So a simple example being, let's say if you are opening a bank account, which is the simplest example I always give. So I, as an individual opening the bank account, is the data principal. I'm providing data to the data fiduciary, the bank. And thereafter, the data fiduciary may appoint further other processors for the purpose of processing my data and the other data processors. A significant data fiduciary, again, is an organization which is handling a significant amount of data. Now, there is no form of categorization. Now, we will come to that in the rules part, which we are discussing later in this session, that there is no particular bifurcation made that, only certain number of records, except in case of e-commerce and certain other companies. But otherwise, it is left quite much to an organization's assessment that they are a significant data fiduciary or not. And accordingly, they need to comply and submit the compliance to the Data Protection Board. The next slides, please. Just run through the slides. I'll tell you where to stop. We are not going through the provisions of the Act right now, only the rules. That is why we are just going to run through the Act. Please go ahead, Sai. I'll tell you where to stop. Yeah, please stop here. Back. Please go back. So what's the importance of the rules over here, which are still in the draft stage? So I understand there's a lot of hullabaloo about, oh, we need to start complying with the rules. Please understand, this is still in the draft stage. Yes, there won't be too many alterations from the draft to maybe the major version that comes in later. There would be changes here and there based on that. primarily with respect to timelines of implementation and all, which I had earlier on also multiple times told when organizations and individuals would come, till the rules don't come, what are we supposed to comply to? The Act. The Act is what contains the entire chunk of compliance. The rules are merely supporting. Even now, if you will see the rules, it merely is the procedural aspects about how the functioning of the organization will be, how you have to go ahead and appoint a consent manager, the registration process for a consent manager. So these things are more procedural, which are not directly fully linked to your level of compliance. You, in which case, have to comply with the Act, which contains the major chunk of compliance provisions. Apart from that, yes, the blacklisting, whitelisting of organizations and different nations for data sharing, that would happen only via notification later. So whether the rules are there or not, I think it's a wake-up call for all of you. You need to start complying. All the provisions are there in the Act for the same. Again, there are lots of consultations I have heard happening on the Data Protection Act, and I will just share my views on that. So a lot of consultations happening are about changes wanted in the substantive portion of the law. Please understand whether it may be child consent, whether it may be different provisions pertaining to data collection, mapping, reporting. Those are substantive provisions of an act which is already enacted. That is the Data Protection Act. That cannot be amended by a draft consultation on the rules. The rules are only pertaining to the limited points mentioned there and a limited scope of the procedural aspect of facilitating the act, the substantive portion of the act. So the substantive portion of the act is not going to undergo any change basis any consultation. So what the consultations primarily are aimed towards is when there is a timeline being provided to organizations. So which organizations would be in a position to comply better, faster? Certain provisions have a longer timeline. So whether how much should be the timeline given to organizations to comply with those particular sections or rules, or how exactly that should be. Those are the main things that are of concern. You cannot change the Data Protection Act. Please keep that in mind. So much of deliberation that I see in so many platforms happening on so many points of the law, that is not going to change. So constructively, it's very important that we give our suggestions on what's actually going to happen, what's actually mattering in the consultation, which is about industry-specific timelines needed, industry-specific current implementations, new implementations for which timelines needed, a lot of things from a very practical perspective that we need to share with the ministry that would actually enable any changes to this existing draft. So again, coming to the draft provisions, now as the rules itself at the outset mentioned, it is about creating digital by design itself. So not the concept of where digital security or data security is being put on the top. It is your design itself has to encompass that. Now, how would that end up happening then? If an organization is compliant to data privacy from the outset itself, like from the employee level to the processes to the organization's new developments, which means privacy has to be embedded within the organization. So if you see Rule 3, 15, 21, 22, all of these are supposed to come in force and at a later date. So the consultations are primarily on the concern of every industry, which date, how it is supposed to happen, what is your comfort zone. That's exactly what it is. It's not about the substantive points. It's not about what the provisions already are. The next point about the consent notice. The Rule 3 mentions a consent notice, a procedure for a consent notice. So I'm quite certain all of you who have read the Act would know that the consent is required to be provided in all Indian languages. It has to be a well-documented consent. It cannot be bundled. It should be explicitly a tick box or explicit acceptance of the consent. All of these provisions are there, and Rule 3 further enunciates that only as to how a valid consent has to be there. And basis that valid consent is what your entire processing is based. If you do not have a valid consent, please understand at the outset itself, your processing is illegal of the data or collection of data is illegal. So either ways, the consent notice is what is covered in Rule 3, which is one of the most important aspects. Rule 4 is about the registration of a consent manager. So there can be multiple organizations or individuals who are going to provide their services to act as consent managers. Now, the Data Protection Authority, upon receiving an application, may conduct an inquiry, publish particulars on their site on what is the procedure for making an application, what are the criterion for that, if an organization or individual is fulfilling that criterion with their application or their methodologies, then they would be empaneled as a consent manager. Also, the procedure for warning and suspension, that will be determined by the data protection board at a later date as to how exactly the consent manager will be operating. There will also be notifications notifications published to that effect as to how the warning and suspension procedure with respect to consent managers would work. Let's say if they are defaulting in something or the other. The next slide, please. Rule 5, the state can process personal data for subsidies, licenses, and certain other situations with respect to national interest. So yes, again, a lot of hullabaloo as to how the state may misuse your data that is happening. That is not in the scope of the consultation, because the Act already allows the state to process your data without your consent in certain mandatory situations, like there may be emergencies, for subsidies, for certain situations, like if you're applying for a license, you're applying for certain facilities from the government, then yes, they have to take your consent. But in a situation where there is an emergency, national interest, they may bypass your consent at that point of time. So you cannot change that by a consultation at this point of time, or advisories to the government at this point of time. This is purely subject to the Rule 5, which is stating how the state can process your personal data for certain situations. In case of legitimate situations of providing you services, there are further provisions also in the rules which state that they have to have reasonable security safeguards. Where there is national emergency or any other situation for public interest, so there may be, let's say, a pandemic or any other public interest situation, when obtaining consent may not be the right interest at that point of time, national interest, then in that situation, they are free to process your data in order to work for the national benefit and for the benefit of the citizens, which seems quite practical. Obviously, in a situation of national emergency, I'm quite certain nobody would be in a position of taking and giving consent at that point of time. Your safety and security, national safety and security would be priority then. Rule 6, which talks about reasonable security safeguards. Data fiduciaries, or on its behalf, a data processor, have to have certain data security mandatorily. Anonymization, obfuscation, masking, and virtual tokens. These 4 are very clearly mentioned, which are necessary in compliance. There isn't any ambiguity in the same. Data security also needs to be documented well mandatorily with a proper data privacy framework, data security framework, data breach framework. You need to have all of these things well in place, which is practically implementable and demonstrable to the data protection authority. The next slide, please. Mandatory access control is mentioned, detection methods for unauthorized access, investigation and remediation. Detection methods should not just be your policy frameworks of the organization, but also the actual tools and methodologies that you are implementing in your organization. Maintenance of data integrity, absolutely important. So data integrity is something which is absolutely necessary. So from a policy perspective in the organization, from the implementation perspective of the organization, along with that, the technology being deployed for data integrity, even the same comes for access control. So when you are having access control to different data sets in the organization, how the entire access control is being maintained in your organization, the legal perspective, the policy perspective, the technology perspective, all of these have to come together. All of this is very clearly enlisted in the rules, in very simple, plain English language. For investigation, all logs and personal data has to be maintained for a period of 1 year, which means there has to be log retention policy, there has to be personal data retention policy. Investigation for data policies, that is in the case of any investigation agency seeking data, what would be the process to provide it? How would that be provided in an encrypted form? Which form? How would that data be segregated and kept for a particular duration? You need to have those internal policies to explain the same and draw a full chart of how it would happen. Contractual obligations between data fiduciaries and data processors for reasonable security compliance. So if a data fiduciary is handing over data for processing to a processor, there have to be proper contractual obligations imposing data security compliance, data policy compliance of the parent data fiduciary. All of that should be there. Obviously, it should be supported by annual or routine data audit checks also. Technical and organizational measures should be there. Yes, this is a term which has been kept open. Technical and organizational measures, what that includes also, at the latter part, I will give you a list of what that would actually include as a best practice for your organization. The next slide, please. So breach notification, 2 parts to it. So when there is a breach notification by the data fiduciary, here within the organization, there has to be a complete clarity of the breach happening and the entire steps being taken in the case of a breach notification to the board within 72 hours of the prescribed time period. Now, Rule 7 also lays down that to the board, you cannot just say, I have been breached. You need to provide the exact details of the breach, the number of data principals whose data has been breached, or the data subjects whose data has been breached. How has it been breached? What mitigation steps have you taken? Thereafter, what is the remediation that has been provided and done by you? Have you notified each of those data subjects? The future implications of that, all of this needs to be consolidated, and that is exactly what constitutes a well-drafted breach notification. Obviously, a poor breach notification, a poorly drafted notification would attract penalties, but a well-drafted, well-worked on breach notification, which clearly requires also you to be compliant, because otherwise in 72 hours, you will not be able to do that much as specified. So compliance coupled with well-drafted breach notification is what would ensure that you are not penalized. Rule 8, data erasure and time period, 48 hours before erasure, very important to inform a data principal. So whenever there is data erasure happening, 48 hours prior, you need to again inform them. If they wish to retain their data, the data principal has to give their explicit consent for the same. The entire procedure for that also has to be drawn up in the organization. The next slide, please. Rule 9, every data fiduciary has to publish the details of a DPO or any other person appointed on their behalf to on the behalf of a data fiduciary. So this either on the website or any other portal, they are required to furnish the details. So Rule 9 is very, very interesting. So for many organizations asking, do we require to appoint a DPO? Yes. So if you're a significant data fiduciary, a DPO is mandatory. If you're not a significant data fiduciary, but a data fiduciary, you do require to have a person who is answerable on behalf of the organization and doing the data protection compliance, basically spearheading. So they may not be actually doing the activity of the compliance day in and day out. It may be outsourced, it may be within the organization through a team, but the person who is the face of it. So there has to be either ways a data protection authority, a data protection officer or a data protection in charge in the organization, even if you're not mandated as a significant data fiduciary. Rule 9 makes it very, very clear that an organization has to have a DPO or a DPO-like person, irrespective of them being a significant data fiduciary or not being a significant data fiduciary. So that's one of the very important aspects. I think Rule 9 plays a very important role in organizational structuring out here. Rule 10, minor and disabled person, verifiable consent. Very important that in case of minors and disabled people, there should be actual verifiable consent. This can be done via ID token, a virtual token mapped to the original using a DigiLocker. Now, there are many other concerns. If a person is disabled, cannot see, cannot hear. So there are multiple methods of taking consent, because especially it will happen in every single Indian language. So it can happen through audio, it can happen through video, it can happen through multiple other methods to ensure that individuals are able to give their consent. There are technical and organizational measures is a very open term, wide term. So if I'm able to consult and tell you even at this point of time that these are all the open methods available for you, then in that methodology, an organization also has to utilize their innovation to understand everything that would come within the ambit of these terms. The next slide, please. Now, in Rule 12, if there's a significant data fiduciary, annually a mandatory DPI and audit is there. It's required to be submitted to the board. But please do not be under the impression that if you're not a significant data fiduciary, you don't have to have a DPI or do an audit. If you see again Rule 9, where there still has to be a person appointed for compliance with the data protection, and then what else is the compliance of the Act. So whatever it may be said and done, eventually you are going to be compliant with the Act. You're going to do the entire compliance under the Act. Rule number 14, which is cross-border data transfer. The government, maybe by general special orders, will determine how data transfer may happen. Obviously, that's also based on the interpersonal relations between the nations, how things pan out between different nations, whether it is suitable for data processing, the risks associated with it, multiple factors. The Data Protection Authority will act as a digital office, so they will not have a physical court body. So basically, the Data Protection Authority is like a court. They're going to hear, there's going to be complaints, there will be hearings, inquiries, evidences taken. So like a court proceeding. Now, this court proceeding will be happening in a digital office medium, that is through a virtual medium. There will be no physical office for the same. Under the second schedule to the rules, the standards for data processing by the government and its instrumentalities are also laid down. So the government cannot just randomly collect your data and not adhere to proper security standards. They also have to adhere to standards which is laid down in second schedule. The next slide, please. The next slide, please. Next slide, please. Next slide. Yes, please enlarge the deliverables for DPDP compliance. Please enlarge that entire list. Yes, please, the previous slide. The slide, please, the previous slide, if you could enlarge that entire checklist. Not this slide, the previous one.
Just a second, ma'am. I'm just trying to.
So what technical and organizational measures would mean, that is exactly the checklist that you would have to understand. Just enlarge this, the deliverables part fully. Yeah. So first of all, a good privacy policy. So a privacy policy, I would always suggest that is not cut, copy, pasted. It has to really suit the data of your organization, your organizational methods, because the cut, copy method may not work, because this is not just a random regulator. This is not just certifying body. Somebody is going to come and see what are the documentations and just sign off on it saying you're compliant. This is actually a proper litigation in the case of a breach. So please ensure every single word, every single line matters. It has to be a proper privacy policy encompassing everything you do and the risks that you have as an organization. Again, a well-drafted consent, a well-drafted data governance policy of the organization. Very good data security policy should be there, data disaster management policy. So you're supposed to report breaches in 72 hours. So a very sound data disaster management policy is what is going to enable you to be able to actually draft a good breach notification within that duration of 72 hours. Incident management policy, how would you really manage the entire incident? That also needs to be fully outlined. Department-wise data protection compliance, day-to-day basis data handling regulation within the organization. All of this framework has to be there. DPDPA compliance and advice. The next part over there, but down, drafting of requisite documents. So there would be multiple requisite documents. For example, the relation that you have with your vendors, the relation that you have with your employees, the relation that you have with every third party that your organization is dealing. All of that should have DPDPA and privacy encompassed into those agreements. And that is something which even the rules mandatorily outlines. Existing all vetting documents should be vetted well. So whatever contracts you have already signed with the organization should be vetted well to ensure that you are not exposed to any liability. In the way that let's say if the person the organization further in the chain suffers a breach, and the entire liability comes on you as a data fiduciary, because yes, even if the processor fails, eventually it is the data fiduciary who's going to be prosecuted, and upon payment of the penalties, etc., the data fiduciary can go ahead and at a later stage via civil remedies recover money from a data processor. That's a very difficult process in the civil court to do that. So yes, the main person answerable will become a fiduciary. The main person who has to pay up will be the fiduciary. The thereafter recovery from the smaller companies down the chain is always going to be way more challenging. Building 3 master frameworks for compliance is necessary: data security, data mapping, cybersecurity. A proper framework for DPI, which is data protection impact assessment. Please do not have checklist-based DPIs or common DPIs, which 100 companies are going to do for themselves. See, those AI-based modules, they are a superficial DPIA, but eventually the human mind is going to be needed, because the DPIA has to be suitable for your organizational needs again. Developments of business happening in your organization. So the same thing, the same format will not apply for, let's say, one DPI that has happened in 6 months, and the other DPI in 6 months may be drastically different. So don't go for that standard methods, because that in a case of litigation will not stand. Because over here, understand, when you are going to be facing a data breach litigation, in that situation, every single word, line, that is exactly what the whole job of advocates and lawyers is. They're going to pull apart everything that you're going to submit in a court of law. So please ensure that these are not just cut, copy, pasted random documentations or standard tools, just AI based being put here and there. It has to be genuinely for your business. It has to convey the intent of compliance. It has to show actual compliance. The next is employee consent, especially because almost all organizations are processing a large amount of employee data. So there has to be proper consent for that, management for that. BYOD, MDM policies in an organization. Training your employees, very, very important. Data handling policies within your employees should be very, very clear so that you are able to go ahead and even explain to your employees on a routine basis how to handle data, new situations of data, new things. So they need to have a basic working knowledge so that they can also hold your hand through the data compliance journey. So with this, I come to the end of the session. And yes, please, in case of any questions, please feel free to ask.
Thank you, ma'am. I request all the participants, like if you're having any questions, you can either drop it in the chat or you can please raise your hand so that we can unmute you.
So I have a question, Puneet. That was an excellent overview, really. Thank you so much for that, and clarified so many things. Yeah. So one question I have is this: Certain has issued directives saying that the breach notification needs to be within 6 hours and so on. So how does this fit in with the other government guidelines, or not guidelines? They're directives. They're binding, right? Those certain and all that. Yeah.
Oh, well, these are very brilliant legal terminologies. So I understand why people would be confused. If you will see the rules, it says within 72 hours. It doesn't say you have a timeline of 72 hours. So based on what the other bodies will say, for this sector, it may be 6 hours. For this sector, it may be 7 hours. Please, the words are very, very important subject to litigation, for interpretation and litigation. That is why I told you, don't go for standard tools which are going to do your DPIA, do all this, because eventually now you're dealing with a judge, you're dealing with advocates in litigation, and all these, each and every word within 72 hours, within means there is nothing that you have a 72-hour period. That is the maximum period sectorally, based on regulators, based on other organizational requirements. There would be a tweaking of how many hours are there available for you.
Okay, because the certain directives are very, very strict in the sense.
Yes. So yeah, I was expecting this question, but yes, every single word has an interpretation, and that matters a lot. So that's why I said, blindly going ahead and just cut, copy, pasting, or maybe just running DPIA tools, that may not work in a court of law eventually because of these small things, like just what you pointed out, Sriram.
Okay. Thank you so much. Yeah. There seem to be a bunch of questions. Sai Prakash, would you read them out?
Yes, sir.
At least
I'll be reading
ones.
out. Yes.
Yeah.
Ma'am, there are a couple of questions in the chat. The first one is, can you explain why a data disaster management policy is required in context of DPDPA?
Well, obviously, data disaster is something that you need to obviously plan for in an organization. So I would tell you earlier on, the bigger disasters are what, risk management. So as a matter of fact, I would say the role of CROs are also broadened by this particular rules. So CROs now need to consider data risk as also one of the important risks that come within the ambit, not just earthquakes, not just pandemics, not just other kind of organizational risks like strikes, etc. But data risk itself is one of the major risks that they're dealing with. And accordingly, they need to have proper methodologies and frameworks, just as you would have a plan for other forms of risks in the organization. The CRO needs to also work on data risk as one of the major frameworks. This would come within the ambit of the CRO. The Chief Risk Officer, again, to just elaborate them.
Yes. Any tentative date by which DPBI would be formed? Kindly advise.
It will be in the news.
Can a legal counsel or lawyer provide consent on behalf of his or her client who is disabled?
A legal guardian can. Again, what is the contractual obligation between the advocate? Is there a power of attorney? There are multiple other implications that are there on the basis of which consent may or may not be a valid consent.
If the incident is addressed or closed within 72 hours, still we need to inform?
Any incident happens, you have to inform, whether even if you close it in 5 minutes. The
How do
reporting
we-
timeline is up to 72 hours. It's got nothing to do with that you have 72 hours. If you handle it, then you don't need to report. That's not how it is.
The next question is, ma'am, how do we reconcile DPDPA and rules with data laws from other jurisdictions like GDPR, US data laws in the event of non-alignment? This is in the perspective of third-party agreements, where if one of our vendors who may be based elsewhere cannot comply with DPDPA requirements, as it may lead to violation of their jurisdiction laws, for example, log retention period.
The log retention period is of a particular period over here up to that period. So that is also subject to interpretation. So yes, our law is drafted in such a manner, every other nation will be able to comply with us, including GDPR. They're all aligned. So if somehow you have developed an opinion or somebody has given you an opinion that it is not possible to do that, please connect with me separately. It definitely is. And all organizations, all different jurisdictions can work together on the DPDPA, aligning it with the GDPR and all the other laws which are there. I'm seriously telling you that all of them are aligned. So where you have obtained this opinion, they are not. I think there is some error in that itself. And whatever your agreements may be, they need to be vetted and put in line in such a way that they're compliant with all the three jurisdictions.
The next question, ma'am. Who can be an independent data auditor? Do the rules specify their qualification or experience or specific empanelment?
Yes, under notifications and further documentation under that which would be issued, there would be specific criterion even for auditors who would have to be empaneled.
How can a data principal confirm if her data has been deleted after its purpose is served?
Well, that is exactly the organizational methodologies and technical methodologies that the data fiduciary has to have. So if after my erasure, I reach out to the organization and seek proof, he has to provide me proof. सिर्फ ये बोलना कि मैंने डेटा डिलीट किया वो काफी नहीं है, आप वो समझ रहे हैं. जब हम टेक्निकल एंड ऑर्गेनाइजेशनल मेजर्स बोल रहे हैं, आपने वो प्रूव करना है मुझे, मतलब आपने प्रॉपर मेथोडोलॉजी आपने क्या अडॉप्ट करी है और कैसे ये आपके सिस्टम में अभी नहीं है, उसका प्रूफ देना है. So saying it is not there is not the answer. Proving it is not there is what you need to provide a data principal and the data protection authority.
If we have implemented SaaS, software as a service based applications, then who will be responsible for collected data?
You are the person who is collecting the data. You may appoint 10 other people to do whatever activities for you, 10 other softwares to do whatever it may be. But the data fiduciary is the person who is the brain. So today he may appoint 10 people to do 10 things separately, but that doesn't mean that he's not the fiduciary and it can be passed to any other processor.
Can you please clarify whether the retention period of 1 year of logs is from the date of collection of data or from the date of incident?
1 year of collection of data, that is with respect to different sectors, for wherein there would be a data log collection which will be mandated, let's say for banking till the service is provided or anytime beyond that. So when you're talking about provision of a service, it is still the period of provision of service. And beyond that, as per sectoral regulations, so for tax purposes, etc., wherever additionally required, or erasure has been sought, or as per your own consent policy, till what period you're going to retain the data. And in case of e-commerce companies, in case of certain other organizations which are there, specified in the rules where there is a timeline of 1 year, 2 year, which is specified. 1 year, this is mentioned over here from the perspective of incident.
Is the obligation is to report actual incident or a suspected incident too?
Can you bifurcate between suspected and actual? So a lot of times when you're suspecting an incident has happened in your organization, it has actually happened. So yes, that means that you need to have a robust data disaster management, data security in order to be able to identify it really fast and report it within those 72 hours. There's no smoke without fire.
What are implications for security solutions that inspect organizations' data exchange?
I think they are the ones who should first of all be vetted maximum, because they are gaining access to all your data. Are they genuinely DPDPA compliant? Are they genuinely having adequate data security? What is their entire bona fide is something I always tell organizations, first let's audit them. Then we'll think of auditing you. If you are taking any organization to touch your data, you're giving them access to all your data from the perspective of, running their tools on it, providing you data security, providing you cybersecurity, providing you whatever other services that they're giving you on your data in the name of compliance. I would say first thing, let's sit and audit them. Let's see, are they completely robust? And then let us proceed to see what further is there.
Considering cloud-based and spread of geo customers, how is the cross-border rule applied?
It is going to be applied on the basis of whatever the nation specified by data cannot be shared. Then unfortunately, whether or not your cloud service provider is facilitating, you are willing to, you will still have to go ahead and modify it in such a fashion, or maybe look for a new service provider.
For a small organization of 50 to 100 employees within an IT team of 10 members, like which has mostly outsourced its IT infra management to a third party, what is the expected increase in budget and which mandatory roles now will need to be identified post DDPA?
The first red flag for you should be if you have outsourced your entire IT services, please, you will need to first of all start checking and auditing all those service providers, because any lapse at a data processor's end with the data is going to render this organization liable. Now, whether or not you have 10 people or you have 50 people, it depends upon the nature of data that you're dealing with and overall the scenario, your nature of business, nature of risk, nature of data. Combined with all of that, irrespective of the size of organization, you will have to be compliant. What technologies can be deployed, cannot be deployed, again, is highly specific to the organization, the nature of data, the nature of risk, and exactly which are the geographies you're dealing with.
What is the role of consent manager and how is DP assisted?
Consent manager basically is the middle part who's going to manage all the consent either from the data principal perspective, even from the data fiduciary perspective. See, managing consent is not going to be so easy manually. So there has to be some automated method. So wherever as a principal I'm giving my consent, there will be a documented planned chart. I have given consent in so many places, I'm withdrawing consent from so many places, etc. So managing my consent will happen through one consent manager, even for a data fiduciary. The managing of the consent, there are so many data principles whose data they're dealing with. So whose data has to be deleted, what automated reply, because a reply has to go within a particular duration. So a reply has to immediately go. Thereafter, managing that consent, deletion of consent, rectification, the entire chain of data has to be managed with respect to the data principle. The automation of that is what the data consent manager does.
Ma'am, there are another couple of questions. We'll just take another 5 to 8 and then we will
Oh, there are
wind
5
up.
to 8 more.
Yeah.
Okay.
Yeah.
This seems like, what do you say? Kaun banega crorepati? I feel I'm sitting at now.
This is very
I need a
interesting
prize
session.
money.
No, it shows that your session was very interesting.
Did the Act define which data needs secure handling?
Digital personal data. So whether it's personally identifiable data, personal individual data, it's all within the ambit.
Is there
You
any
touch an individual's data, you are there in the ambit.
Yeah. Is there any data retention period for educational institutions?
There are going to be further rules also with respect to this, especially whether it's pertaining to children, and that will be bifurcated completely within that.
In cases where PCI DSS applies, would the provisions of DPDP Act prevail or more stringent provisions of PCI DSS apply?
DPDP is always a law of the land. PCI DSS is just a standard. So the standard is something which is going to align and support whatever legal compliance you're doing under the Act.
How to understand whether a professional firm will fall under the definition of data fiduciary?
Almost every organization is falling under the definition of data fiduciary. If you have employees whose data you're processing, individuals, customers, vendors, you're processing information or storing the information pertaining to their personal identifiables or anything that can identify them as them, whether it may be email IDs, mobile numbers, anything of that nature that's identifying them as them for provision of a service or for any particular business activity, you are coming within that ambit. Yes, if you're a very small organization, then under the rules, you're exempted for it at this point of time. So like standalone doctor clinics, etc., are exempted for this point of time.
And last two more, ma'am. Would personal data of OCI, Overseas Citizen of India, be covered under DPDP Act, especially those who are working in India or have property or bank accounts in India?
So if you are doing something or the other in India, and many of them also have dual citizenship, so yes, there are questions in that. So overseas citizens, majority of Indians have taken up dual citizenships and a lot of other situations that were there in the middle. And apart from that, also many of them may be Indian nationals with bank accounts here, etc. So then in that situation, that does raise certain questions because they're citizens of another country. But then also then you either have the US laws, you have the GDPR, and you have the Indian law all intersecting together. So you may try to dodge the bullet from here to there. You're still going to hit a bullet if you don't comply.
Yeah. Is it mandatory for all data fiduciary to engage consent manager?
How are you going to manage your consent? So as long as the number of consents are smaller, you would be able to physically manage it. Else, yes, it may become humanly overwhelming and impossible for you to manage. But as I again said, before you engage any organization, very important, before you hand over your data to them and you run their tools. So it's a very interesting thing. I've seen a large number of organizations saying, we will secure your data. The biggest question arises, are your systems secure enough to secure my data? So I think organizations, before thinking whether it's required or not, need to start making a very good assessment of, are you secure to secure me? That's the first question that arises, considering the level of penalties.
Yes. Yeah, I guess that's it, ma'am. Due to the other time constraints and
So I have one last question. Sorry,
yeah.
one question, Puneet, is that in this day of AI systems, there's always a thing saying that the AI system took a lot of data and processed it, morphed it, did machine learning on it, and used it. And so this guy will say that, yeah, that acted as a data fiduciary, but there's the AI system which did it. I didn't do it.
So that is not how it works. AI also is an algorithm which has been created by human mind. So the data fiduciary is responsible for the same.
Data fiduciary in the sense he says that I really didn't authorize. I mean, it's the AI system which learned and did that.
See, the AI system is based. So I'll tell you, there are multiple international case law precedents on this subject, wherein AI basically the most rudimentary form of AI, how it was. So I'll just give you one example. Sriram, I'll take a few more minutes.
Sure.
I think I'm exceeding the time, but I will take a few minutes and explain to you. So there was this very interesting case law which was there. This is about 25 years back, when AI 25 years back was not so advanced at that point of time. So there was a very well-known footballer who was known to have diabetes, and soccer is what it is called, not football, soccer. So there was a soccer match that was taking place. And in those times, I'm sure many of you, when you've seen cricket matches at that time and even soccer matches, when a particular player who endorses any particular product is playing on the field, you see certain images coming on the field when he's playing, like hologram images that come up, isn't it, pertaining to that particular player or whatever his endorsement is. Now you don't see that nowadays. Definitely you have different forms of advertising. At one time it was that hologram based, you saw those images on the ground and in the stands floating. So what had happened is this particular player, he was basically diabetic, and there was a very rudimentary AI based algorithm that on which the soccer match advertising worked. So whenever any player who was endorsing something, so the how does AI basically work? So situation A, then yes. Situation B, then no. Situation C, then no. So that's exactly a simple thing. If I have to just simplify AI for a child, it will be A situation yes, B no, C no, D no, E subject to A and B situations. That's how exactly logical programming is done. Now, on the basis of the logical programming, A would mean the situation that it should play. The advertisement should play when the player is playing on the ground at that point of time. Now, what happened in this particular case was that this player was a diabetic. However, when he was playing, there was a image of candies that started coming on the football ground. So people watching it on television, people who were there on the ground, they saw candies all around. Now, one lady who was of middle age, she ended up eating candies. She was diabetic. She said, I presumed it to be diabetic safe because this person, this footballer, he always promotes diabetic safe products. And, that is exactly what his agenda is. Now, how am I supposed to presume that these toffees are not diabetic safe? She landed up in hospital. She sued him for millions of dollars. What ended up happening? This obviously went into litigation. And the organizing authority and the footballer had to pay. The reason being the programming of that particular program that determined that this particular advertisement of the chocolate should be coming. Ideally, on situation A, it was when it was supposed to play, which means that maybe some other product that he was endorsing. It should, in situation B, which is of the toffees, it should not have played. But this clearly meant that there was a programming error that took place, an error of logic programming for an AI. In AI, you have logic programming, which is the first step to it. So that exactly was where there was a deficit, which means the programmer is held liable. which means the organization involved in the programming is held liable, which also means the organization deploying it is held liable. So everybody had to be penalized. And this is something like 25 years back.
Things are clearly much more complex now that they mix and morph various things and generate new stuff and all that kind of thing. But really, that's a subject for another and a topic for another day. And certainly, we'll rely on you there also for any help there and one session probably in future. Okay, thank you so much, Puneet. Yeah,
Most
for
welcome.
doing this, and really, it was very enlightening. Thanks so much for coming down and answering all the questions patiently. Your knowledge is
Yeah, I
simply
just felt like I
incomparable,
was in a
really.
KBC show for sure. It was just back-to-back questions.
And excellent knowledge. We are looking for interesting times in the coming days, and really we hope that the whole field of privacy, the profession, and privacy engineering, pets, and all these things grow as they should. Because 137 countries in the world have adopted privacy laws, and if you're doing business with any of those countries, we need to be compliant. So this entire
Yes.
profession should grow. Okay, thank you so much, Puneet.
Most welcome.
Yeah. Thank you, Dr. Shriram. And once again, thank you so much, ma'am, on behalf of the Cybersecurity Center of Excellence and the entire cybersecurity and privacy community of Hyderabad and the other parts as well. So thank you so much for joining us today and enlightening our participants on the draft DPDP rules. And I also would like to thank all the participants who joined us today for this wonderful session. And I request all the participants to stay back. Just a second. I request all the participants to please, fill the feedback. This will help us in order to, bring out more such wonderful sessions to you and to understand, on which more topics would you like to have these sessions, and that will encourage to, bring lots of such good speakers and, give back to the community. And the coming Thursday, that is the Jan 30th, we are having another session of called Privacy Spotlight, where we are hosting the CISO of Envoy Global, Mr. Subhajit Dev, who will be presenting on the human risk management. So, a Privacy Spotlight, the CISO and DPO series is our monthly webinar series where we'll be hosting a CISO or a DPO, enlightening our participants on a different areas of cybersecurity and privacy. So, we request all the participants to sign up to this wonderful session again. Yep. And anyways, we'll be mailing all these details to you to your registered mail IDs. Thank you so much once again. I thank the speaker and the participants for joining today. Thank you so much.